Hello friends, very warm welcome to my business laws channel. Friends, this will be the fourth video to the LLP Act 2008. So the chapter is before you, which is partners and their relations in LLP. Firstly, friends, I've given all possible questions from this chapter. How can a person become partner in a LLP? What are the disqualifications for becoming a partner in a LLP? Then second question is regarding designated partner and the various provisions in respect of designated partner. How can existing partner cease to be a partner of LLP? What are the consequences of cessation of a partner? What is the liability of a partner upon reduction of minimum number of members in a LLP? Explain the extent and limitation of liability of LLP and its partners. What are the various provisions regarding extent of liability of a partner in a LLP? Discuss the provisions of LLP relating to contribution. Then the last question is relating to whistleblowing, meaning and the provisions which have been provided under the LLP Act 2008. Now friends, I'll cover all the questions and their answers in this video. What is LLP? You all know, friends, LLP is the association of two or more persons who have set up their business structure for carrying all lawful business with a view to earn profit. Because LLP can be set up only for economic purpose or profitable purpose. And LLP must be registered. LLP is always created by a legal process which is known as registration. Now, who is eligible to be partner in LLP? The following are eligible to be partner in LLP. How can a person become a partner of LLP? Person can become a partner of LLP in two ways. By subscribing their name to the incorporation documents. And then second is, he can become a partner in accordance with the LLP agreement or LLP deed. Okay. So if he has subscribed to the ID incorporation document at the time of incorporation or registration, then he will be the partner. Or if he wants to join later on, he can join as per the terms and conditions which have been laid down in the LLP agreement. Definition of a partner. So partner has been defined under section 2(1)(q). The term partner in relation to a LLP means any person who has become a partner in the LLP in accordance with the LLP agreement. Either he has subscribed to the ID or he has become a partner later on as per the terms and conditions laid down in the LLP agreement. Then definition of body corporate. Now, who can be a partner? According to section 5, any individual or body corporate may be a partner in the LLP. So who can be a partner in the LLP? Any individual or a body corporate can be a partner in the LLP. So body corporate means, any LLP which is registered in India, any LLP which is registered outside India, any company which is registered in India under the Companies Act 1956 or 2013, or any company which is registered outside India. So friends, this is the meaning of the term body corporate. Then who is not eligible to become a partner of LLP? The answer for this has been laid down under section 5 of the LLP Act 2008. According to this section 5, person cannot be a partner if he has been found to be of unsound mind by the court. He doesn't be a sound mind. He is of unsound mind. He has been declared by the court to be of unsound mind, or he has applied to be adjudicated as insolvent and his application is pending in the court. You all know the meaning of the term insolvent, friends. He has given the application, but his application is pending in the court. So these two persons, they are not eligible to become a partner of LLP. Then what is the maximum and minimum number of partners? Now, as far as minimum number is concerned, the LLP Act 2008 has laid down there should be two partners. But The LLP Act 2008 is silent about the maximum number of partners. Reduction of number of partners below statutory limit. So Section 6 of the LLP Act 2008 lays down a minimum number of partners is 2 normal partners, because there may be normal partners in the LLP or designated partners. So minimum number is 2. But if at any point of time this number falls below 2, that is only one partner is left out, and that partner carries on the business of the LLP for a period which is not less than 6 months, then he will be liable for all the transactions which take place during this period. He will be solely responsible. So this is the consequence of reduction of number of partners below the statutory limit. Now, who is designated partner? Designated partner has been defined under Section 2(1)(j) of the Act. The term designated partner or DP means any partner designated as such pursuant to Section 7 of the Act. Now, what are the various provisions relating to designated partner? Number of designated partners. Friends, before the Amended Act 2021, the designated partners were 2. Every LLP used to have 2 designated partners, but now the number has been raised. It is up to 5. So the maximum limit is 5 designated partners. Who will be a designated partner? How can a person become a designated partner in the LLP? By signing to the incorporation document, or if he wants to join later, then in that case he can join as per the terms and conditions of the LLP agreement. But he will have to give all the persons who would like to act as DP, they will have to give their prior consent as a designated partner. This consent has to be given online. For this, new amendment rules, they have been incorporated in the year 2022. Filing of particulars with the registrar. All particulars are to be filed with the registrar. Any change in the DPs, if the DP ceases to be the DP of the LLP, any person who joins as a DP, all particulars must be filed with the registrar within the specified time. Now, what are the eligibility conditions for the appointment of a designated partner? Now, who cannot be a designated partner? So, who is not eligible to be a designated partner? Now, eligibility conditions for the appointment of designated partner has been laid down. If he has at any time within the preceding 5 years been adjudged insolvent, he suspends or he has any time between the preceding 5 years suspended payment to his creditors and has not at any time within the preceding 5 years made a composition. Composition means compromise with the creditors. He has been convicted by a court for any offence involving moral turpitude and sentenced in respect thereof imprisonment for a period which is not less than 6 months. Has been convicted by a court for an offence involving Section 30 of the Act. So friends, all 4 points I have talked about, a disqualification of the designated partner. Such person cannot be appointed as designated partner in the LLP. Now, obtaining DPIN. Now, earlier, at the time of incorporation, only one DP, it was obligatory for one DP to obtain DPIN. But now, as per the new rules, which have been given recently, as per Second Amendment Rules 2022, it is must for all the DPs to obtain DPIN because they will have to sign, put their digital signatures at the time of incorporation. So obtaining DPIN, it is must for all the designated partners to obtain DPIN. DPIN stands for Designated Partner Identification Number. And this DPIN entitles the designated partner to put his digital signature certificate on the online document. Now, liabilities of designated partner. The role of DP. DP plays a very important role. Designated partners' responsibilities are similar to company secretary or director in case of private limited liability company. So the management ownership divide inherent in a company is not there in the LLP. In case of LLP, the management lies with the ordinary partners and designated partners who are authorized by the LLP agreement. So what are the liabilities of DPs? As per section 8, their liabilities are they are responsible for doing of all acts, matters, things as are required to be done by the LLP in respect of compliances of provisions of this act. That is, any document has to be filed, return, statement, report, as may be specified in the act or may be specified in the LLP agreement. Or they are also liable to all penalties imposed on the LLP for non-compliance of provisions of the act or LLP agreement. Now, next point relating to DP is changes in the designated partners. All changes in the DPs, any change which takes place, DP resigns or the designated partner ceases to be the designated partner of the LLP, then in that case, all changes must be brought to the knowledge of the ROC within the specified period. And the last point is regarding penalty for contravention of section 7, 8 and 9. Now, amendments have taken place regarding the penalty provisions. In the next video, I'll be taking amendments in all penalty provisions. If there is a violation of section 7, section 8 and section 9, and apart from this, more sections also. All amendments in the various penalty provisions I will be covering in the tabular form in my succeeding video to LLP Act. Now moving ahead, the next heading is partners and their relations. How are partners and their relations determined? Partners and their relations are determined in two ways. First point is they are determined by LLP agreement, and second is they are determined by first schedule to the act. So LLP agreement, you all know friends, it contains various rules and relating to mutual obligations and rights of the partners. But it is not obligatory for the LLP partners to draft this LLP agreement. In case they decide to draft LLP agreement, then they'll be bound by the provisions of LLP agreement. But in case they decide not to draft LLP agreement, then Schedule 1 to the Act will apply. So in the absence of agreement, the mutual rights and duties shall be determined by the provisions as provided under first schedule to the Act. And these provisions, friends, 14 points are given. All the points, are almost the same, which you have studied in case of partnership. So friends, you can understand they are self-explanatory, and if you still find any problem, you can always write in the comment section and immediately, I will reply. Next heading is, how can an existing partner cease to be a partner in the LLP? A person may cease to be a partner in the accordance with the agreement or in the absence of agreement by giving 30 days notice. If he wants to cease the LLP, then he will have to give 30 days notice to the other partners. According to section 24, subsection 2, a person shall also cease to be a partner of LLP if on his death or dissolution of LLP, if he dies or LLP is dissolved, or if he is declared of unsound mind by the court, if he has applied to be insolvent or he has been declared as insolvent. In such cases also a person shall cease to be a partner of LLP. So what are the consequences of cessation of a partner? Now, if any partner ceases to be a partner of LLP, it becomes the duty of the LLP partner to give notice of his cessation of a partner. If no notice is served, then in such a case, that person who has ceased to be a partner of LLP continues to be a partner of LLP. And LLP will be liable for the act of that partner because notice has not been served. Obligations of the former partner. Former partner, any person who ceases to be a partner of LLP is known as a former partner. And such former partner shall not be liable for all the transactions which take place after his cessation in the LLP. He will be liable for all those transactions which take place when he was a partner. But all the transactions which are taking place after his cessation, he will not be liable. Rights of former partner. Now, former partner or his legal hire will be liable, will be entitled to get the accumulated profits if the profits have not been given to him on his cessation, if he is alive, or to his legal hire if in case he has died. So still, the former partner or his legal hire, legal representative has the right to take accumulated profits and the interest thereon, from the LLP. Registration of changes in partners. All these changes, are to be addressed in the name or address in form number 6 within 15 days of such change. Partner has to inform about such changes in form number 6 within 15 days of such change to the LLP, and LLP has to inform all these changes within a period of 30 days. File a notice with the registrar within 30 days if any change in the name or address of a partner. And there are penal provisions also. Friends, I have told you that amendments have taken place in penalty provisions. In my next video, I will be covering all these penalty provisions which are amended one. Liability of LLP and partners. So what is the liability of LLP? Every partner of the LLP is for the purpose of the business of the LLP, agent of LLP and not of the other partners. Now, there is no mutual agency element here. He is agent of the LLP. He is not the agent of the other partners. LLP shall be liable to full extent of its assets and liabilities of the partners of LLP is limited to their agreed contribution. So there is limited liability concept in case of LLP. So every partner is liable up to the amount of agreed contribution. In case he has contributed his agreed contribution in the LLP, then his liability will be nil. LLP is not bound by everything done by a partner. Already I have told you, friends, that there is no mutual agency element in the case of LLP. LLP is liable if partner is liable. So LLP will be liable. Of course, if partner is held liable, then only the LLP will be held liable. An obligation of LLP, whether contractual or otherwise, shall solely be the obligation of LLP, as LLP has separate legal existence. So all the liabilities, creditors of the LLP will be the creditors and liabilities of LLP alone. Liabilities shall be met out of LLP's property. So all the assets of the LLP shall be regarded as assets of LLP alone. And all liabilities shall be met out of LLP property. That is, partners' personal properties will not be utilized for the purpose of discharging liabilities of LLP. Extent of liability of partners. Sections here are 28 to 30. Agency relationship. This is a point which is overlapped. There is no agency relationship in case of LLP. Every person who is a partner of the LLP is the agent of LLP alone. He is not the agent of the other partners. He cannot bind with his own acts the other partners. No personal liability for obligations of LLP. He is not at all personally liable for the obligations of LLP. But there are certain cases where the partner is held liable on personal basis. That is one of the points I have discussed, that in case the number of partners falls below statutory limit as per section 6, then in that case, such partner who carries on the business for a period which is more than 6 months, it is not less than 6 months, then he shall be held liable on personal basis. Liability in case of holding out. If he has held out to be partner of LLP and the third persons, they have believed on that statement and they have lent some money to the LLP, then in such a case, such person shall be held liable to the extent of holding out. No liability after the death of a partner. Now, if unfortunately any partner dies, then his legal representative or legal hire shall not be liable for all the transactions which have taken place after his death. Unlimited liability in case of fraud. Now, unlimited liability in case of fraud, though there is concept of limited liability in case of LLP. But if any partner of the LLP or employee of the LLP has committed fraud with the third parties or with the creditors, then in that case his liability will be unlimited. And amended provisions I'll be discussing in the tabular form when I'll be talking about the penalty provisions. Liability for compensation. Any person, employee of the LLP or partner of the LLP has caused loss to the third person, then in that case that partner or employee shall be liable to compensate the other person for the loss. So these are the various provisions relating to the extent of liability of partner which have been provided under sections 28 to 30 of the LLP Act 2008. Now, two headings are left out. One is the whistle blowing and second one is the contribution. What is whistleblowing? Whistleblowing may be defined as the disclosure by organization members of illegal, immoral or illegitimate practices under the control of their employees. Anything which is not legal, anything which is against good morals or it is illegitimate, health hazards are there, some unlawful act is committed, okay, then in that case, his whistle is blown about him to the internal organization, internal management. And if the management, they do not hear this complaint, then they do, after hearing this complaint, they don't take any action against the guilty person. Then the whistle is blown to the external persons, law enforcement agencies or media people or to the general public. Now, protection has been given to the partners or employees under the LLP Act. Friends, if the whistle is blown against the wrongdoer, then wrongdoer, develops this spirit of revenge. He thinks that other person who has blown the whistle against him is his enemy. And in the past, such whistleblowers have been murdered also, or they have been demoted. But a lot of protection has been given under Section 31 of the LLP Act 2008. Now, what is the protection which has been given to the partner or employees under the LLP Act 2008? Now, I would like to discuss these points. There are 2 points here. The first point is the court of tribunal may reduce or waive any penalty leviable against any partner or employee of LLP if it is satisfied. That is, any partner or employee who has blown the whistle, if some penalty has been imposed upon them, then the tribunal may reduce such penalty or even waive such penalty. When it is satisfied that, first point is, such partner or employee of the LLP has provided useful information regarding the investigation of such LLP. Now, whatever information he provided, it was very useful in the investigation. And second is, when any information given by any partner or employee, whether or not during investigation, leads to LLP or any partner or employee of such LLP being convicted under this act or any other act. So whatever information he has provided in the investigation, that was very useful information, because on the basis of that, the wrongdoer has been convicted under this act or under any other act. And the second point is, no partner or employee of any LLP may be discharged demoted, suspended, threatened, harassed, or any manner discriminated against the terms and conditions of this LLP or employment merely because of his providing information or causing information to be provided. Friends, if he has blown whistle, it does not mean he has committed murder. He has committed offense. So he should not be demoted, should not be suspended. No threat should be given to him. No harassment of such person. Okay, so this is also one of the points relating to protection which has been given to the partner or employee under the LLP Act 2008. So friends, this is all about the whistleblowing meaning and the provisions relating to whistleblowing. Now this is the last heading which I would like to take up now, contribution. What is contribution? Now I would like to discuss these points. What is contribution? Now contribution is equal to the capital which is introduced by the partners in the partnership firm. It is introduced to share capital about which we talk in case of a company. Whatever partners contribute to the LLP, that is known as contribution. No requirement of minimum contribution. How much the partners will have to contribute? It depends upon the LLP agreement, or it depends upon the provisions of Schedule 1 to the Act. Because LLP drafting of LLP agreement is not mandatory. Form of contribution. How much or in which form the partners should contribute to the LLP. It is not necessary, friends, that a contribution should be made in terms of money only, by cash only. They can contribute in cash, they can contribute by way of movable assets, immovable assets, tangible assets, by way of goodwill, copyrights, patents, or expertise. So there are various ways, there are various forms of contribution to the LLP. Obligation to contribute. It is whatever contribution has been decided, it is the obligation of each partner to contribute that amount. And if he has not contributed up to that amount, his liability will be up to the amount which he has not contributed. Because there is limited liability concept in case of LLP. Now, as the partners can withdraw from their capital in case of partnership firm, similarly in case of LLP, if the partners decide that partners will have the right to withdraw from their contribution, then they will be given this facility to withdraw from their contribution. And the creditors will have the right to enforce original contribution of the LLP. So this is all about the various headings I have under this chapter, and I have answered all the questions which were given in the beginning of this PPT. It is all from my side, friends. If you have any doubt, you can always write in the comment section. Do subscribe to my channel if you have not subscribed yet. Do press on the bell icon to get notifications of future videos. Keep smiling and stay blessed always. Okay, friends, goodbye. We'll meet soon.